Good morning, everyone. Virgo here. It is August 20th, 2019. Happy Tuesday to everyone. And I wanted to present to you the newest of the classified information that has been sent to me by Agent Sock Puppet. As you can see, we have a picture of the leaned Toys R Us store, and the Moors have turned it into the Moors R Us. Complete with their flag hanging, and on the right-hand side there you'll see Shafirian Officer Parking Only. This is the new National Consult headquarters, so I wanted everybody to actually see the picture that was taken by Agent Sock Puppet. So today we're going to be talking about the warrant that is on Sharon Tracy Gale Bay's docket. We're going to be going over a lot of information that people want to know with regards to this specific situation. I have received so many emails over the last 12 hours, I can't even tell you guys. So I'm going to go over exactly what to expect from this point forward after speaking to a Pennsylvania attorney, a criminal law attorney, and after talking to a bail bondsman who gave me additional information on what can be expected, time frames, and how the process works. I'm going to go over all of that with you right now. Okay, so first, I know I went over this with you really briefly in a little 2-minute video to try and get the information out to you guys last night. But let me go over this docket one more time with you so you kind of have an idea of where the information is in case you want to look at this on your own. And this docket, of course, will be located in the description or in the comment section of this video. All right, so the one thing that actually changed yesterday, and I know this was a question of one of my subscribers. I read it in the comment section. They didn't ask me specifically, but they were saying they didn't know how long this case had actually been inactive. Okay, I witnessed the inactive status go on yesterday. So the court appearance that she did not show up to must have been yesterday, because if it hadn't been, the inactive status would have been showing up on the docket prior to this. So with an inactive status, and there still are all of the charges that are pending, what we've got is a situation where a defendant has not shown up to court, and therefore a case goes from active to inactive simply because they can't proceed with the trial or hearing because the defendant isn't there. All right, so they put the case in an inactive status, as you can see there. Leave basically everything as is. So as you can see, the second line is from with yesterday's date at 9:30 a.m., Judge Richard M. Capelli, and it still shows as scheduled. All right, and then we go down here with all of the actual charges, 14 of them. And we continue to scroll down until we get to the section that shows us entries. All right, and in this case, it's the very, very last entry, which shows us a bench warrant for the county of Delaware, issued in the county of Delaware, and of course the costs that are associated with that. All right, so we can put this up against the other case, which would be the Pitts case, and you will notice that there is a big difference. Number one, we know that DeCorey Pitts is actually incarcerated in county right now, and you'll see his case status shows as active. And the reason behind that is because he's clearly already there. So he as a defendant, he was there. So his case is active, and that's the only update that actually there was no update on his at all. Everything is at a standstill because Sharon chose not to show up to court yesterday. All right, so let's take a look at what it is to have a bench warrant. Okay, so here's some information from got.law. This is a criminal defense failure to appear fact sheet. It will give us some information with regards to what the courts can and can't do, so on and so forth. So I'm just going to go over this with you quickly because there's more to take a look at here than just this failure to appear and inactive status. What is a failure to appear? Charge when a person is obligated to show up for court for any reason but does not appear. The judge may choose to issue a warrant for their arrest, known as a failure to appear or an FTA bench warrant, which is what was issued out for Sharon yesterday, as you saw from her docket. It is a bench warrant, a failure to appear bench warrant. The most common FTAs in the United States involve traffic violation charges where people forget to show up for their court date. Below explains what an FTA warrant means, what options you have, and how you can properly turn yourself in for an FTA warrant. All right, now I know they're going into traffic stops, so on and so forth here, but let me just stop and share something with you. It does happen, but it's more rare that when someone puts up collateral and cash to bail you out, as is the case with Sharon, 10% of a $50,000 bond is what had to be, bail bond is what had to be put up. 10%. And then when you go to a bail bondsman in order to do this, collateral has to be put up that is at least the amount of what the full bond would be. That collateral remains with you and in your name until such a time that either the case is finished and the defendant is either found guilty or innocent and the case is over with, or in a situation where they take off, then you have to look at the possibility that you may lose that collateral and your cash. We're going to go over that in just a minute, but let me just say that this is kind of different because in most cases, people have enough forethought about the people that are putting up collateral and bail and signing their name for you to not just run away and not show up to your court dates. That's why they're going over this and making the claims that generally it's just traffic stops that this happens on. But there are times, of course, more times than should be, that it happens with criminal cases such as Sharon's. What can happen if I fail to appear for court? If you do not appear in court, it is a criminal offense, and depending on circumstances can result in additional fines, fees, and bench warrants being issued. Once a bench warrant has been issued for your arrest, several things may occur, including but not limited to: routine traffic stops will result in arrests if police run your information through the system. You may be denied bail. You may be held in jail after you are arrested. You may be slapped with additional charges for failing to appear in court. Your license may be suspended until your case is closed, resulting in additional fees to reinstate your license. How long does an FTA charge stay on my record? Okay. FTA charges do not have a statute of limitations. They'll follow you forever, literally. The attorney that I spoke to yesterday said the state of Pennsylvania and most other states, they never expire. You're never, ever going to see a statute of limitations on a bench warrant. It's going to have to be dealt with one way or another, which means you're going to have to show up in court or show up at your police station in order to clear this up. FTA charges do not have a statute of limitations and thus will remain on your record until you serve the warrant. States often will not extradite people out of state for FTAs unless the original charge was very serious. This one is. Risking a catastrophe is equivalent to manslaughter in the state of Pennsylvania. For those of you that were not aware of that, you can look up the state legislature and the state laws, if you look up 3003, you will see that that particular law, risking a catastrophe, is the equivalent to a manslaughter charge. It's very serious. How do I get rid of an FTA charge? If you think that your charges may be categorized as severe, it is advised that you discuss your options with an attorney before making any decisions. That being said, once a warrant is in the system, there's really only a few ways to get it removed. By surrendering yourself and making an appearance before the judge, by getting stopped by the police, getting arrested and taken to jail until you make an appearance before the judge, by having your attorney come to an agreement over the terms of the warrant. This can only happen in some misdemeanor cases. So we're not dealing with a misdemeanor case. We have several misdemeanors in this case, but the majority of the serious charges, of course, are felonies, and therefore being in front and making an appearance before the judge is going to be necessary. Plus, we have to consider the fact that Sharon Tracy Gale actually has no attorney. She's pro se. All right, let's take a look at the consequences. Since FTA charges and the circumstances surrounding them differ so greatly, it's hard to say what your individual case's consequences will be. As would be expected, the severity of the charges typically depends on the severity of the crime, but the court has grounds to slap you with prison or jail time, increase the terms of your probation by years, or charge you with a new crime. Your driver's license may also be subject for suspension if you fail to address an FTA warrant. If the DMV decides to suspend your license, it is illegal to drive until you serve your bench warrant and receive a courtesy clearance from the courts. All right, so what we are actually looking at here is not a traffic offense. So we need to keep that in mind when reading this, but this was just an easy way to send me somewhere that I could actually get some basic information with regards to a bench warrant. For those of you that would like more detailed information, feel free to put your questions and comment in the comment section, and I can address them individually based on the conversation that I had with the criminal law attorney. Okay, now we are going to be looking at the secondary issue that's going on with Sharon Tracy Gale Bay. First, I'm going to go ahead and take you back here to where the bench warrant information is, and we're going to actually take a look at the fact that there was bail that was paid, and you can see that bail was posted here, and it was posted by this individual. That was done on April 18th of 2019. This person right here, this one, that's the person who's responsible, who signed off on the bond. Paying someone's bail and putting up collateral is the responsibility of the person who bails you out. This is a concern for this individual. So here's what's going to happen. The very first thing that's actually going to occur is that the court, or has already occurred, the court contacts the bail bondsman agency. Once the bail bondsman agency has been contacted, a bench warrant is issued by the judge. Both of those things have already occurred. And there's this process in Pennsylvania. This is the process that I'm reading to you. Once that is done, the bail bondsman notifies the party who put up the 10%, who took out the bond to bail this person out. They notify them that there is a 30-day grace period if the judge gave the full amount of time that Pennsylvania generally allots for, 30 days. If the judge is particularly peeved, they don't have to give that length of time. But the length of time that generally is given in the state of Pennsylvania is 30 days. That gives the party that put their name down on the bond and put up collateral 30 days to locate Sharon and get her to turn herself in. If that 30 days approaches and that has not happened, collateral and money is gone. There is another avenue called a fugitive recovery agent, otherwise known as a bounty hunter. In the event that the party cannot be located easily by the person who put up the bond, they have the option to hire what's called a fugitive recovery agent, a bounty hunter, in order to locate this person and bring them into the police department so that they can recover at least their collateral. Otherwise, whatever was put up as collateral for a $50,000 bond will be owned by the bail bondsman should it become a situation where within that 30-day period or whatever time the judge agreed to allot for Sharon to show up and go to court. Otherwise, if she doesn't show up in that amount of time, sorry, Charlie. So, just so that you guys are aware, this is how this all works. Trying to find that. Okay, here we go. Let's see if I can get you over. Okay, so you can see right here, this is from a website called stuckinjail.com. This is an article about posting bail in Pennsylvania and the 5 things you should know. And of course, number 5 is, what if I miss a court appearance? And it says, in Pennsylvania, failure to appear is a separate crime, and a bench warrant will be issued for the defendant's arrest. A co-signer, which is the person that bails you out, or bail bond agent has a 30-day period to get the defendant to return to court and argue for the bail to be reset. If that doesn't happen, the defendant and any co-signer must come up with the entire amount of bail for either a surety bond or a 10% bond, which was already provided, so the chances of having a second one are slim to none, according to both the criminal attorney, the court, and the bail bondsman agency. It just does not happen in these courts very often that someone is given a second opportunity to screw over the co-signer, the bail bond agency, and the court. All right, something someone else had asked that I wanted to address. Why is it that the judge does not have any kind of responsibility come back on him for allowing this sort of thing to happen? My understanding, after speaking to a couple of different people with regards to this, unfortunately, I wasn't able to speak to a judge about this, but I did speak to a criminal attorney who informed me that under normal circumstances, the prosecuting side will actually suggest whether or not a person should receive bail. Ultimately, yes, the decision is made up by the judge. However, they take great, I would say, they try very hard, let's put it that way, to cater to both sides of the argument. So they take a lot into consideration when it comes to what is suggested by the attorneys. So of course, if it's your defendant and you are an attorney, you're fighting for that defendant to get bail. And of course, the state side wants to make sure that if you do get bail, you get bail that justifies or is going to give the best possible outcome of you showing up to court based on what you've been charged with. Well, we know Sharon didn't have an attorney. She was presenting everything herself, and she was given a $50,000 bail. So some of that had to do with the prosecutor's office. Some of it had to do with the charges. A lot of it had to do with history in terms of her criminal history. And some of it had to do with what the actual judge that she saw for arraignment felt in terms of her demeanor and her ties to the community, etc. So the judge that currently has issued a bench warrant isn't the same one that agreed to allow Sharon out on bail. They're two totally different judges. One did the arraignment, one is doing the hearing. And a lot of this has to do with the charges, criminal history, so on and so forth. As you'll notice, Sharon got $50,000 of bail, but Mr. Pitts had a $250,000 bail and is still sitting in county because of it being so high. My gut tells me that chances are they really didn't feel that she was a flight risk. As we've seen, the individuals who like to pull this paperwork stuff, which of course they didn't know up front, are never a good flight risk. But again, the magistrate that saw Sharon at the arraignment within 48 hours of the arrest, actually it was sooner than that, would not have known what we know now and what they know now. So they have to do it based upon, again, the charges, criminal history, the demeanor in the courtroom. It's based on a whole lot of things. And I know they do the best that they can. Quite frankly, if there was a way to have removed that bail after finding out the arguments, that's what I would have done as the judge. I would have actually pulled the bail back and said, hey, no. But that isn't what happened, and we are where we are at this point. So now it's a matter of it being a 30-day chase for the police locating Sharon, arresting Sharon, or Sharon turning herself in out of either doing the right thing and dealing with this like a woman, like an adult, or the person who put up the bond finding her and forcing her to go back and turn herself in so that they don't lose anything more. So we just have to wait and see at this point, but we'll be keeping a very close eye on it. For those of you that have individual questions, please feel free to put them in the comment section, or you can email me at virgotriad@protonmail.com. This will be my only video today unless there's some big breaking news of some sort. I have a bunch of personal stuff that I've got to get done, and I'm working on a new documentary for you guys on Patreon that will be coming up in September, the beginning of September, so I'm really excited about that. But like I said, I'll try to get to your questions as soon as I possibly can. And tomorrow we have Snoop for Truth Day. So I look forward to that also. I hope everybody has a wonderful Tuesday, and I'll talk to you later. Bye-bye.